Yeah, just basically. Possibly that it's like, looking at problems with this.
All right, thank you everyone for coming, calling to order the boards of estimation, calling to order the Board of Contract and Supply. Today we have President Catherine Fitzpatrick from Budget Department, Darius Shankar from the Treasurer, Robert McGee, Corporation Counsel, William Trudeau, City Engineering. First item on the agenda. Mr. Zioli offers the following: resolved that the secretary be authorized and directed to advertise for the bids for the following: landfill pumps, gas blowers, skid parts, preventative maintenance and repairs. Bids to be received, said proposals to be received by the board at a regular meeting held on Tuesday, May 5th, 2026 at 1:30 p.m. and that a bid deposit is not required. First opening for Ravo equipment, preventative maintenance and repair, Northeast sweepers and rentals. Bid bond is not required. We will forego reading the amounts as it's a total of the result is. It usually says to forego the reading. The labor rates, that's the bid. And these are the labor rates. And you can see. You can read that. It's just like my. Total bid, $39,119.16. Labor rates, normal shop rates, $195 an hour. Normal field rates, $227.50 an hour. Emergency shop rate, $235 an hour. Emergency field rate, $260 an hour. Mileage rate for mobilization, $4.05 a mile. Mileage rate for equipment transportation, $6.50. Next item. Mr. Zioli offered the following: resolved that the bid for the following named bidder be accepted and the contract awarded to them and for the prices specified in the proposal, they being the lowest qualified bidder, theirs being the lowest bid, and that the mayor be authorized to sign a contract on behalf of the city that fix it sealed there too. Project title: vehicle equipment, hydraulic pumps, hoses, fitting, and related parts. Was awarded to Meridian Hydraulics. For the various rates listed. Mr. Zioli offered the following: resolved that the bid for the following named bidder be accepted and the contract awarded to them at and specified in the proposal, they being the lowest qualified bidder, theirs being the lowest bid, and that the mayor be authorized, excuse me, to sign the contract on behalf of the city and affix it sealed thereto. Project name is Sidewalk Opening and Restoration Services. The winning vendor is Peter Luigi and Brothers Contracting. Next, we have Mr. Trudeau offered the following: resolved that the bid for the following named bidder be accepted and the contract awarded to them at and for the prices specified in their proposal, they being the lowest qualified bidder, theirs being the lowest qualified bid, and that the mayor be authorized to sign the contract on behalf of the city and affix it sealed thereto. Project title: PIN 1762.31, Frisbee Avenue Rehabilitation Bicycle Pedestrian Infrastructure Project, Department of Engineering. Lowest bidder was James H. Malloy, winning bid amount $2,853.00. That concludes the agenda for the Board of Contracts. Now I have a motion to accept.
So moved.
Darius,
Second.
Joe, all in favor?
Aye.
A motion to adjourn.
So moved. Second.
Thank you.
Thank you.
Bye.
The last. This is The meeting. All right.
Right, so we have a meeting of the Business Investment Exemption Industrial and Commercial Incentive Board, which is organized under RPTL 485B. According to RPTL 485B, the city council at some point, looks like in 1980, yeah,
Might want to note we have a quorum here.
oh, sorry.
Yeah.
Yes, we have a form of a representative from the mayor's office, the treasurer, I don't do this a lot, our city auditor, Sam Fine, as well as the assessor, Trey Kingston, and our city clerk, Shaniqua Jackson. So,
Is Shaniqua part of the board? No.
well,
I'm here though.
Okay.
I thought you were part of VNA, I apologize. All right, so, we have, it, at some point, it's my belief around 1983, our city council created the Industrial and Commercial Incentive Board for the purpose of overseeing some aspects of this exemption. We have in front of us, which was provided to the board a few weeks ago, and I have copies for anyone interested now, an application for the property at 66 Colvin Avenue. We might be familiar with this. It's part of the old Armory Garage.
As well.
Yeah, which was recently converted into a self-storage facility.
Yes, it will.
So under with the exemption that is found in state law provides for a 10-year exemption, which scales back from 50% to fully taxed in increments of 5%. So it goes 50, 45, 40, 35. However, the city in our city code has elected to amend that schedule. So it's still on the books as a 10-year exemption, but the last 5 years are at 0%. So in practicality, it's a 5-year exemption, which goes 50%, 40%, 30%, 20%, 10%. That percentage is applied to the increase of assessed value attributable to the renovation. So at various points during the renovation of these properties, we were reached out by the property owners and we did on-site inspections. And the assessment, the base assessment that we were looking at was $1 million with an increased assessment of $4.2 million. So the exemption amount that would be applied here is 50% of $3.2 million. In year one, 40% of that amount in year two, 30% in year three, 20% in year four, 10% in year five, and then it would be fully taxed, barring a citywide reassessment at the $4.2 million going forward in the 6th year on. We had some discussion today, as you know, I think that Darius and I are the only members of the board that are here. Last time we had a meeting, there was a lot of discussion today regarding the board's purpose. And how far into that should I go, do you think?
I think, some questions have been raised by a council member, and unfortunately, the 2 council representatives who are on this board are not able to make it today, I think. But that because of neighborhood opposition and not caring for this project, that I'm not sure we were asked to vote against it, but the sentiment was that if that person had a vote, that they would vote against it. And we had discussions today about whether or not that is within our purview, for those reasons as a basis. My understanding with this, as well as I think it goes with the 485A exemption, which is similar here, that these are essentially as bright, that we don't really discretion other than if you as the assessor botch this completely.
Yeah, so and I talked to our city auditor about an hour ago, and I briefly talked to Darius about this earlier. The board is really created, if we look at the city code, in order to create boundaries where we want to apply this exemption and to exclude other areas, and to put into writing certain types of industry and commercial uses are going to qualify and exclude other kinds. There was some opposition, as Darius brought to our attention, this morning about a self-storage facility getting this exemption. But it's my opinion that is irrelevant because this board has never taken that action. We have never limited the scope of location or type of commercial use as is really what we're intended to do. So I fully encourage this board to reconvene as soon as possible, and we can create these rules But it's not my opinion that the board has the discretion short of those to discount anything that is purely commercial. The law specifically states that this will not apply to anything used for residential or transient residential use, such as hotels. But as far as our city code and the state law goes, as well as the fact that this board has not restricted any areas of the city or commercial uses, I don't think that the board has the discretion to vote against this as it stands right
Unless
now.
there's an error in here.
Unless there's an area. And I just want to reiterate, after speaking with Sam a couple minutes ago, we did actually try to do this a couple of years ago and try to create these limitations but it didn't get any legs. But
With the city council?
yeah, with this board,
With the board.
we can do unilaterally. And it's my strong opinion that if we were to take no action, or if we were to deny this, that we would be pretty easily defeated when this was challenged in Supreme Court.
In the event of a lawsuit.
Yeah.
And I'll add, yeah, I share the concerns of the council member, and it's very helpful talking with Fred about this. I think, if we did have the discretion, if the purpose of this board was to determine our opinion on whether or not it's worthy, and they don't know, but I understand that that's not our role. But I do think it's very important that we reconvene as soon as possible to take a full look at what criteria we allow and what geographic areas we allow. I do have concerns that we're giving this exemption to just to a storage facility, and take a full look at what types of industries we allow to get this exemption, which we don't.
Do you think it's something that's subject to bringing to the council to eliminate the exemption and its intent?
Well,
I guess this is really, that's kind of outside the scope of the discussion today, but.
I mean, if I'd like to answer it anyway, I mean, if you don't mind, it's, with the reality of the city's tax rate, I think that the intent behind this is to incentivize redevelopment and rehabilitation of commercial properties. And, this is a project where we have a threshold of projects that are worth going to the IDA. And this helps smaller projects, stabilize, because it can save them taxes over time while they're obtaining occupancy. In this case, it's renting storage units. In other cases, it might be, commercial. But I know, there are some discussions about dissolving the 45-day altogether. I think that's for completely different reasons. This is only a 5-year exemption as compared to the 13-year exemption. And I think that if we still had problems after we established geographic locations and commercial uses, that might be, but that should be the first avenue that we take.
Do we, does this board also have the authority to review 485A?
No, that's as of right.
Or are there, but in the same way, do we have we don't have the ability to set criteria before? Are there any other tax exemptions that this board has similar authority with?
No.
This board only reviews 485B.
Yes, and I've been through.
Very, very rarely.
Yeah.
Do you have a list, could you pull a list of
The
all
only
exemptions
one-
we've given over the years?
The only one we have on the books is the Popeyes over by Mount Hope Way.
Okay,
That's the only one, because it's short. So 2017, we had Mo Kiber's liquor store, as well as a few, like 2 or 3 that came about right then. And then we had Popeyes, which is probably on its last year. So the only one on the books right now is Popeyes.
huh. I'm surprised that more businesses haven't applied for this.
Most of the larger projects tend to go through the IDA, from a cost perspective, I think, and they, a 5-year tax exemption is not as much as most of the pilots that go through the IDA.
20 years usually.
Right. It's a 5-year sale.
Do you think it's worthwhile to go through president's session with saying that does the council? And speak more candidly about all our partners here?
It's okay with me. Do you feel if it feels necessary or wise?
I don't have a problem with it.
Okay. So I guess I'll make a motion to go into executive session. Have you handled executive sessions with this? It's gotta go off.
Yeah, I'll go off.
Okay,
Yeah, I can do
all
that.
right, okay.
I'll keep the feed going, but I'll cut the cameras in the
Okay.
side. That way I don't have to restart it and reconnect it to the computer.
All right, so we're gonna go into executive session, and receive advice of counsel. I'll move it. Second,
Second.
all's in favor?
Aye.
Aye. Okay. Go into executive session. I guess we'll say that on the record.
No,
We exited executive session, which probably you should say it, I think, but yeah.
We've exited executive session, no decisions have been made. At this time, I want to point out to the board that a representative for the property owners is attending the meeting. Pat Sealy is their attorney. He is in the room with us, and I don't know if anybody had any questions regarding the project for Mr. Sealy.
I mean, this is just a storage facility and, normally in an IDA project, we would ask for a but the project would not have gone through, but for this, tax abatement, but I don't know if that's the case here. Myself, I don't know if you have anything you'd like to add or?
Yeah, I can tell you that it was certainly my client's thought process on that, and just so you know, they're only about 2/3. You know, rented, they're not, this hasn't progressed along the way they hoped it would go. So, you know, this exemption helps them get up to speed. While they're sort of getting the business off.
Okay. Any other thoughts here? So we're in a position where we perhaps do have some discretion here. I think you disagree.
I don't disagree. I completely agree with, Rob's, where he's showing us the language that shows discretion. Where the two issues that I have here is we haven't done anything to establish the board's purpose. And also this isn't how the city has historically acted. Where I am a little bit, reserved with latching on to the discretion and things like that is for what I just stated, and I 100% want to establish these rules and regulations and make it very clear going forward. I don't, I just don't think that we do it while there's an application in front of us, completely understanding all the other steps that are found in our city code. But I don't think that it's equitable, which if you spend enough time in my office, you hear me say that way too much, but it's not equitable that we're gonna hold the property owner to these standards when the board hasn't upheld their own standards of establishing what we're supposed to establish. So ultimately, I agree, like I said before, nothing that's been said in this meeting is incorrect. It's just a mess, and I think that we should clean it up going forward. I recommend acting on this how the city historically has, and then we can make a serious change to this going forward.
So could you clarify if we tabled it, it's too late for. Unless we tabled it and we ended up approving it in a month. It's
No,
too late
because-
for it to apply to this year's tax rolls.
I mean, so the tentative assessment roll comes out on May 1st. I lose control of the assessment roll on May 1st. I can't put an exemption on. I can't take an exemption off. I can't change a value. The only people that can change assessments is the Board of Assessment Review. So once, we need a decision by May 1st.
But if we pass it after May 1st, it could go to the Board of Assessment Review and they could approve of that?
No, because the Board of Assessment Review has the ability to review what was contained on the May 1st assessment roll. So property owners have the ability to challenge the contents of the May 1st assessment roll. They can challenge the valuation of the property and things of that nature. But if we wouldn't necessarily be able to grant it after May 1st.
So, but we could grant it, but it would apply to the following year.
Yeah, but I mean, that's something that I'd have to clarify with the county tax director. I'm just saying that because, there is a lot of stuff in the real property tax law, and I'm just on the spot. I want to make sure that I'm not forgetting anything, but if the application is in time, okay, so that's settled, and I'm just kind of talking through my thought process now, so bear with me. I would imagine that it needs to be on the assessment roll by May first, if we're doing everything by the books. There's no reason why it shouldn't be. If. I mean, it just gets into, I mean, I could put it on after May first, but that's just more, the public would have another leg to stand on with the challenge.
And is there like an expectation of legal requirement that we as a board review and approve this by a certain time if they get their application in?
It's not in the law. I think it's just kind of understood that it would be done before the tentative assessment roll is issued May first.
And we could always call another meeting, right, in a week if we wanted to, if we got more
I mean,
information.
What's the notice requirement, 10 days?
They can't do one before the roll is
You
done.
can't do one before the roll's done. That's, yeah, where,
All right. Um. I'm kind of stuck between where we are vulnerable with past practice and where we have discretion, so. I don't know, any thoughts? Mayor's office?
I'm just looking at all this for the first time.
Yeah.
$150,000 over 4 years. I think my from council not to be sitting writing documents in the courtroom over that. So I mean, when I think about the public good, I also include time and not just dollars in my calculation. Leaning on past practice and what we seem to have not done to wait, I'm more inclined to vote in the affirmative.
Yeah. I'd rather not fight over this.
well, and that should say to Sam's question, I think I got sidetracked first. So what's not, the property owner does have the ability to challenge a partial exemption denial. So this is a partial exemption denial. So if we were to deny it, and I would say that even no action on it, when an application was submitted, it wasn't approved. We, like I said to you before, we're probably the most sued office in the city. It's like a standard practice, we'd likely be facing litigation.
We got one more thing. I haven't been in another government role when all those pieces of this project were moving through. I don't remember the storage units being the fight was actually on the affordable housing
Right.
for veterans, that folks were in there saying they essentially didn't want a veterans program in their neighborhood, so I'm not going to, I mean, I probably have a broader lens of what I feel public good is. For me in this case,
Yeah, I think,
it's a little broader.
I think we gotta get our house in order before we,
Start denying.
yeah.
I'm also just saying, we have in the code that considered a public good, public interest, but this is all we really.
That's it, so
Right? I mean,
another part of it, that's the state's RP 5,
Yeah.
45B. And I mean, if you really look at city code, we're supposed to have our own application. It says that.
We are.
Yeah,
Okay.
I believe so, and I could be mistaken, but I'm very sure that this morning I read that this will be applied to the or the Commercial Incentive Board by means of an application so prescribed by the board. So we could call this our own application, but we also have the ability to create our own blank slate.
Where we could actually ask questions
Yeah.
about how it
Yeah.
relates to public interest. And other documentation you may want. Yeah, I remember I was following that as well, it's involved as you, but, yeah, And personally, I view that as housing preventers is in the public interest, but it's. Yeah, this is a separate project.
I mean, it is a short term and the intent of the intent of this, like I've said twice today, it's to incentivize redevelopment, rehabilitation, alterations of commercial property that's not being used. There, maybe I am being overly cautious, but this exemption allows them to reach occupancy stability. And as Mr. Sealy indicated, and I've been working with him for a dozen years now, and I've no reason to believe that he's saying anything that's not truthful. They're 2/3 occupied. This, by granting this exemption, it is in the public good because we're preventing another vacant building. If, like, anybody that's in the real estate world right now will tell you that there was a huge boom from 2020 to 2023 in storage units, and those gains aren't being realized right now. So, we do have the ability to alleviate a little bit of what they're facing right now. That's not the city's problem. But, like Barry said with the budget statement at the IDA, that this process doesn't call for us to do that kind of review in the planning, in that early in the process. But that doesn't mean that the developer didn't have that in their mind during their planning process. So I do understand public good and how everybody at this table can have a different definition of what public good is. But I just wanted to throw that one out there. That occupied self-storage facility is better than a vacant building.
Good point. I mean, I guess I'm okay with it. I think, as you say that, I'm thinking that we
Yeah.
suggested that the time for us to consider what is in the public good is in creating the criteria for.
Yes,
That is-
yes.
That fundamental argument is not dissimilar to what we face in the IDA with properties that are, for residential, converting to residential, they're going underwater, so. What are you gonna do? Have a vacant building there or try to do what we can to build something?
My first one of these types of meeting, type of parliamentary authority that we use, so I want to call the question,
You can call, I can make a motion right now.
please.
I'll make a motion to accept. Or to, well.
To vote on the.
To vote on the
application.
agenda. I make a motion to support the agenda, this is to, in favor of the tax abatement.
Second.
All in favor?
Aye.
Aye. Okay, thank you, everybody.